My name is Natalia Willett, and I'm a real estate attorney here in the state of Florida. And today I want to talk to you about Chapter 83.51 of the Florida Statutes. And what that chapter deals with is what are the landlord's obligations in maintaining leased premises? Now, of course, ideally, you have a written lease agreement that clearly specifies what is expected of you and what is expected of your tenant in terms of repairs. But as I've explained before, the number one cause of disputes is he's supposed to fix this. No, they're supposed to fix this. So here's some clarity for you in terms of what the Florida statutes expects of you. If you have a single family residence or duplex that you are leasing, then you are expected to, number one, comply with all of the local health, building, housing codes. Number two, you have to maintain the exterior part of the property. So roofs, windows, doors, exterior walls, foundations, those structural components, you have to maintain them and they have to be in good repair, capable of resisting normal forces so they can't just collapse with rain, shower. And the general plumbing has to be in reasonable working condition, that is pipings and things like that. You do have to make sure that your screens are properly installed, and if there are damaged screens, then you have to replace them once a year. You also have to install working smoke detectors. Those have to be in those types of structures. What is not required, well, let's say you're leasing land and the tenant owns his own mobile home, you don't have to have any repair, except you're not expected to do any of the repair on something, a mobile home that is owned by the tenant. If you have multi-housing complexes, so not single family, not a duplex, then you are also expected to take care of locks and keys, extermination of rodents and vermin, clean and safe common areas, garbage removal, functioning heat and water and hot water. Those things are expected in addition to the smoke detectors and in addition to, of course, maintaining the structural component of the building. Now, if you have a rental agreement that is written, of course, you are absolutely allowed to require that your tenant pay the cost of utilities and garbage removal and water and fuel and things like that. And then furthermore, if your tenant is the one that whose actions have caused the damage or structural disrepair or whatever it might be that needs to be fixed, then you are not responsible, because that is something that they have, a condition they have created by their own negligent acts or their own negligent failure to act. So you are protected a bit in that regard, but you do have to keep a good track record of what your property looked like before you let the tenant in. All right, investors, hopefully this was a useful guide for you, and good luck out there.